this juncture, the defense is making a motion for judgment of acquittal pursuant to Connecticut Practice Book Section 42-40 and 42-41. The basis for the motion, Your Honor, is the evidence that was submitted by the state at this juncture, and they have rested, does not reasonably permit a finding of guilty to the charge of murder or tampering with evidence. So it is the request of the defense that the court grant motions in regard to both those charges. Thank you.
Attorney Stein?
Yes, Your Honor. Again, pursuant to law, the state would oppose the defense's motion for judgment of acquittal, looking at the evidence that's been presented in a light most favorable to the state. I believe that the state has provided a preponderance of evidence together with the reasonable inferences that the trier of fact may draw from that to believe that the defendant is otherwise guilty of murder and tampering with physical evidence.
All right, Attorney Stein. All right, in ruling on a motion for judgment of acquittal, the trial judge must determine whether a rational trier of fact could find the crime proven beyond a reasonable doubt. A determination of whether the evidence could reasonably support a finding of guilty beyond a reasonable doubt does not require a court to ask itself whether it believes that the evidence at trial established guilt beyond a reasonable doubt. Instead, the relevant evidence or question is whether after viewing the evidence in a light most favorable to the prosecution, any rational trier of fact could find the essential elements of a crime beyond a reasonable doubt. Now, I did, of course, anticipate the defendant's motion as it is commonly made at the close of the prosecution's case in chief. Wherefore, I did receive and review pattern jury instructions. I took notes during the entirety of the state's case in chief. I did receive and review those notes. Additionally, I took a look at the statutes and reviewed the elements relevant to the two crimes charged in this case. And after careful consideration of the evidence presented at trial and the logical inferences that can be drawn from the facts, the court does find that the jury reasonably could conclude that all elements of the crime of each count, that is the crime of murder and the crime of tampering with evidence, could be proved. Therefore, the court's decision is to deny the defendant's motion for judgment of acquittal at this time. So after finding the jury reasonably could conclude that those crimes could be charged, the next step, Attorney Gavin, would be for the defense to decide if it wishes to present a case.
Yes, Your Honor. Your Honor, at this juncture, I represent to the court that we are presenting evidence. For our agreement yesterday, I have Dr. Frazier here at 11 o'clock, and I would inquire of the court if this would be an appropriate time to canvass my client regarding his election to testify. I don't know if you want to do that now or you want to do it after Dr. Frazier.
Okay, so why don't we do that now? I can talk to the defendant if he is in a position to make that determination. Why don't we do that? And I will revisit it just briefly before the defendant takes the stand, if in fact that is his choice, once I canvass him. All right?
May I just briefly be heard, Your Honor?
Certainly.
As of this moment in time, it is the state's position there is no evidence of PCP usage in the evidence. Dr. Frazier being called first is an accommodation to the defense because Dr. Frazier has scheduling issues which will make him unavailable tomorrow and thereafter for a continued period of time. So I believe the court is going to canvass the defendant because without subsequent testimony in front of this jury with regard to PCP usage, Dr. Frazier's testimony would not be relevant to the proceeding. So with regard to this is an accommodation and a failure by the defendant to be able to link evidence, the state will move to strike.
Okay. Attorney Gavin?
Your Honor, I appreciate the accommodation. Obviously, we accommodated the state during the course of the trial to take witnesses out of order, and Attorney Stein's representation regarding scheduling is correct. I've advised my client that, and we'll go through the canvas, but just to respond to that issue, I've advised my client that the state is accommodating us having Dr. Frazier testifying, and that Dr. Frazier's testimony potentially would be stricken if Mr. Morales doesn't want to testify. but Mr. Morales has made it clear to me, and the whole case has been structured in anticipation of his testimony. So if the court, if you think this is a reasonable time, I'd appreciate if we could go through the canvas regarding his election to testify.
All right, so the court just wants to document and thank counsel for their reaching an agreement relative to accepting the expert testimony outside of the nature in which it would generally be presented without argument on the court as to the issue. So I appreciate that. If something changes, the court would entertain motions and those would be decided at that time. Having said all of that and having you both document the record, the court is in a position to canvass Mr. Morales if Mr. Morales is ready. But at this point in time, what is your understanding of Mr. Morales's intent to testify here?
He's prepared to testify today.
Okay.
I just have to put a couple of minor points on the record. He's been advised that his testimony is memorialized and that his testimony can be used for any subsequent prosecution if the state went ahead and decided to do that. So he's aware of that fact. He's indicated to the defense team that he wants his opportunity to go ahead and present his version to the jury, which he is entitled to, and he's prepared to go ahead and do today. I've explained to him the risks of going ahead and doing that he's under no constitutional obligation to go ahead and testify at this juncture, and that no adverse inference would be drawn from the fact if he elected not to testify, but he clearly wants to testify. It's my intention, Your Honor, subsequent to the testimony of Dr. Frazier, to go ahead and put Mr. Morales on and have him testify at that juncture.
All right, thank you. All right, so Mr. Morales, I am going to address you personally at this time, pursuant to our case law, just to make sure that you have an understanding as to your constitutional rights and that you've made the decision knowingly and voluntarily, and having had the appropriate information. I do accept your attorney's representations on the record, but I have to go through some of that information with you individually. So, Mr. Morales, after consulting with Attorney Gavin, is it your decision to testify in this trial?
Yes, Your Honor.
All right, do you understand that you are not obligated to testify, sir?
I understand.
Do you further understand that if you chose not to testify, the fact finder will be instructed to not draw any adverse inferences from your choice not to testify?
I understand.
Do you also understand that your right to testify or to not testify belongs to you alone, and that no one, including your counsel, can prevent you from testifying or force you to testify?
I understand.
And do you feel that you've had enough time and opportunity to discuss this decision with counsel, including any strategy concerning your right to testify or to not testify in your case, and the advantages and disadvantages of testifying?
I have.
And have you understood the information as it was provided to you by your attorney?
Yes.
Okay. So is it your personal decision to testify, thereby waiving your right to not testify in this case?
It is my personal decision to testify.
And you are making this decision voluntarily?
Yes, I am.
No one has forced or threatened you concerning your decision, is that correct?
That's correct.
Have you understood all of my questions?
Yes.
All right, court finds the defendant has chosen to testify and has effectively waived his right to not testify, and he has done this knowingly, intelligently, and voluntarily. So that concludes the court's canvass of the defendant regarding his willingness and desire to testify in this matter.
Appreciate that, Your Honor.
All right, so my understanding is that your next witness, however, is available at the court's direction at 11 o'clock.
That's correct.
We were not sure how long this process would take this morning.
That's correct.
So we are going to go ahead. We will break until about 11:10, give you some time to make sure that your witness is here, get everything in order, including your exhibits, other documents, et cetera, if that's applicable. So the court is going to recess between now and 11:10. The court does hope to come back on the record at 11:10 a.m. Thank you.
Thank
Court
you very
stands in
much, Your Honor.
recess.